Good afternoon. Today I wanted to talk for a little while about something I get asked about a lot. One of the most, I guess, controversial areas that I get asked about a lot is the rights of employees in Texas. And it's interesting to note that, I'm fairly well qualified to discuss this because I have represented both employees in disputes with employers, and I have represented employers in disputes with employees, and I have represented a union as well. So I have kind of a well-rounded understanding of this and point of view about it. Let's start with this notion. All employment is contractual, okay? So every type of employment is based on a contract. Now, remember, a contract is a voluntary legal relationship. No one can be made to be an employee, okay? Now, keeping that in mind, there are three basic types of employment. The most common type of employment is known as employment at will. And basically, it tends to be the least formal type of employment relationship as far as documentation goes. Generally, what happens is that each party, subject to certain statutes that exist, federal and state, but except for those, each party, the employer or the employee, is free to terminate the relationship for any reason or no reason at all at any time. Okay? Now, keep in mind there are some statutes that overlay this point, but that's the general rule. The second type of employment relationship is referred to as employment pursuant to a written contract. In this situation, the rights of the employee are detailed in the written document itself, such as what the term of the contract and the compensation and so on and so forth. The rights of the employee are determined by the written contract itself. Keep in mind, if the employment relationship is for more than 1 year contractually, it must be in writing under what they call the statute of frauds rule. The third type of employment relationship is very different from the first two because of the fact that federal law plays such a prominent role in it. And that is called union employment. Now, in union employment, and let me back up and give you a little history. At one time in the United States, it was actually a criminal offense to promote union employment or try to force an employer to participate in union employment. The claim was it was a conspiracy or combination to fix the price of labor. Union employment became a prominent issue in many respects due to immigration issues, where we had vast numbers of European immigrants who came into the United States in the late 1800s into the early 1900s, and a lot of them were from Europe, and a lot of them were big supporters of guilds, which were the early unions, and union employment. Not so much in the United States. It came much slower, but basically there was a lot of violence attendant to organizing employees that happened in our history. What changed the whole calculus of union employment was the Franklin Roosevelt administration. And the Franklin Roosevelt administration passed the National Labor Relations Act. Of course, this was during the 1930s. And the National Labor Relations Act was a critical piece of legislation because basically it was a federal law that specifically gave workers the power to organize. And furthermore, if the employees, the majority of the employees, elected to have a union as its representative with respect to wages, hours, and conditions of employment, then the employer was required to bargain with the union. Now, that didn't mean that it would result in a contract, but the point is it gave legitimacy to the notion that employees could organize and choose a designated representative to bargain with the employees with respect to wages, hours, and conditions of employment. Now, the reason I think it worked so well in the Roosevelt administration was basically the economy was in difficult straits for much of the time. There was still the Depression going on, and so the government was a big player in awarding contracts and so on and so forth. So the bottom line is that Roosevelt wanted labor peace, and one way to get labor peace was, rather than have the unions and basically armed conflict with the employers, his idea was, let's give the unions the right to organize and elect a union, and then if that's the case, then the employer better bargain with it. Over time, there were some modifications to the National Labor Relations Act that basically made it clear that states could impose so-called right-to-work laws, meaning that you couldn't require someone to be in a union as a condition of employment. At any rate, now that I've kind of given you a brief history, let me tell you basically what the situation is. That if a person is an employee, is in a union, and there's a dispute with the employer, that the employee is to go to the union and ask the union to become involved in the issue. So let's say, as an example, that an employee is suspended for 2 weeks without pay for some alleged violation of a company rule. And if let's say the employee wants to challenge it, the employee can't go and just get a lawyer and have the lawyer sue the company. That's not permitted, because the company and the union have entered into a contract called a collective bargaining agreement. And the collective bargaining agreement is a contract between a union as representative of the employees of a certain unit and the employer of those employees. And the collective bargaining agreement is enforceable under federal law. So that employee, let's say, who's been suspended for 2 weeks without pay, if the employee wants to dispute it, then the employee goes to the union and indicates what's happened, and then usually they go through a first level union representative called the steward, and the steward's usually an on-site employee. And then what can happen is that the steward can talk to the supervisor and see if it can be resolved easily, and then if not, the matter goes to the business agent for the union. And it may be another title, but that's one that I've seen used a lot, the business agent. And then it moves up a notch, and then if the parties can't work it out, if the business agent and the appropriate supervisory people can't work it out, then arbitration is requested by the union typically. And arbitration is where parties agree to select a designated individual to serve as a private judge and rule on a dispute, okay? And one feature of virtually every collective bargaining agreement between a union and a company is there is a provision for arbitration. So at any rate, that means that the employee just can't get a lawyer and have the lawyer sue the company. They've got to go through the union, and if the union and the company can't agree, then what happens is that there's arbitration. Then an arbitrator is selected through a process agreed to by the employer and the union, and the arbitrator hears evidence and makes a decision on the particular issue. When someone files for arbitration, it's usually called a grievance, and then it is ultimately decided by the arbitrator. And unless there are some really extremely unusual facts or some unbelievable abuse of discretion by the arbitrator, then the decision is final. It must be followed. If one of the parties doesn't follow it, the other party can go to federal court and get an order that it be followed. Okay, so that's the union situation. The vast number of employees, though, are subject to at-will rules. Okay, now we get to this issue of what people talk about all the time: wrongful termination. Okay, let's say you have an at-will employee. The employer comes in one day, and the employer has 8 employees. He goes in one day and he just says, John, you know, I know you have been with us the longest, and I know that you've been a very good employee, but I am terminating you. And John goes, why? He says, well, I just feel that it's necessary to do that at this time. Well, I want to know why. Well, I'm not going to get into a discussion with you. You're terminated. Okay. Well, the first thing is that, you know, there are limitations on the employee's ability to compel an employer to explain the reason for termination. Yeah. You'd think that they'd have to say so. Now, here's the thing. If the employer absolutely refuses to indicate the reason for termination after the employee has sent a written request, then the employee is certainly free to collect unemployment benefits. And if the employer goes in and then at that point in time raises some misconduct, well, the fact is that they had a chance to notify the employee of that and they didn't do it. So the employee is probably going to go ahead and get the unemployment benefits. Okay. But understand this. If an employer goes in and let's say he terminates an employee, and the reason he terminates the employee is that's the highest paid employee in the position, and the employer feels I can get the same job done with these employees that are making less. So what I did was I'm cutting back on my overhead by terminating the highest paid employee in a particular unit. Now that doesn't seem to be a good idea. In other words, what kind of loyalty is that? Someone's been loyal as an employee, done a good job. Obviously that they're considered very good at what they do because they're getting paid more than the other employees. Well, the fact of the matter is it might be a moral dilemma for some people, but in at-will employment, it's not a dilemma. Okay? Well, suppose that the employee feels this is some sort of racial or you know, cultural or gender-based thing. You know, I'm going to go to the EEOC. Not with 8 employees, you're not. Yeah, if you're under 15 employees, you can forget the EEOC. The EEOC law, Title VII of the Title VII of the Civil Rights Act regarding discrimination in employment. The fact of the matter is that there are limits on that. Okay, they have the family business exception basically, which smaller employers, they're 15 employees, they're not subject to it. Okay. So, let's get to it, okay? If you're not a union employee, okay, and you're not an employee who's subject to a written contract of employment that expresses the rights of the employee and the term of employment and so forth, an at-will employee is pretty much out of luck. You know, you hear all this wrongful termination. Well, in fact, there isn't much of it because the state law doesn't protect much of it. I mean, they have a few kind of weird things like you can't terminate someone because they won't buy from the company store. So, you know, let's say you were working for ABC department store, and they said what we're going to do is that you have to buy, you know, you have 50% of your check will be used to buy goods at our store, and you know, so you'll get a credit. You'll get a credit on your on a company credit card for half your wages, and then you know you'll have to spend that at the store. And you say, I'm not going to do that. I want all my money. and they terminate you, well, that would be an illegal termination. There's restrictions on terminating anybody because they went to a convention, a state political convention as a delegate. I mean, how many people is that involved? Then there's probably the most common Texas state, wrongful termination rule, and that is called the Sabine rule or the Sabine Pilots rule. Basically, it's a very limited protection, but basically, if the employer asks an employee to do something illegal and the employee refuses, and the singular reason, the only reason that the employee is terminated is for the refusal to engage in doing illegal acts that he was ordered to do by the employer, then that is a wrongful termination. The problem is oftentimes it's difficult to establish that that was the only reason that the person was terminated, even though you might believe it was. Okay. So the fact of the matter is that why is it that employers seem to hold the upper hand in this matter? Well, first of all, let's remember this, that a lot of people tend to think that employment relationship is an entitlement. Okay? It's not. It is a voluntary contractual relationship. And as you know, I mean, in voluntary contractual relationships, if somebody, if somebody enters into it, they have to live by it. Okay? The voluntary relationship does not require many rights be given. It's just like if you have a great employee and you're an employer and you've done everything to try to make this employee happy. You've paid them more than they would normally get. You've treated them with respect. You've complimented the person many times. You've been flexible with days off, all this, and you do all these wonderful things for an employee, and they go off and go to work for somebody else. Maybe they go to work for somebody else because there's a beach in the town where they're going to be working. Who knows? Well, what about the employer then? You're in a real pickle, and so you call the employee, I thought I've been good to you. Why aren't you being loyal to me? And the employee says, hey, you want loyalty? Go get a dog. Okay? Yeah. The fact of the matter is that, it works both ways. Okay? A lot of people don't realize that. There is a tendency to think of some people to think of employment as some sort of relationship where, that you have to cater to employees, or there's all these things that you can't do to employees. Actually, in Texas it's really not that way. I mean, it's the closest thing to a pure, employment at will state that you're going to find. Texas doesn't even have to, an employer doesn't even have to have workers' comp insurance in Texas. So if somebody's injured on the job and their employer doesn't have workers' comp, I mean, they can try to sue the employee, sue the employer. But as far as getting the comp benefits, no, they're not available because the employer wasn't required to get the workers' compensation insurance. So why is Texas such a meanie with respect to employee rights? Well, I will tell you the answers of their governors and many of their state legislators. It's to create a climate where companies want to come to Texas, and that in turn creates more jobs. So the idea is the more employee rights there are, okay, then the less ideal the state is for employers. Don't really know if that's true or not, but that seems to be the theory that's usually offered. What I will tell you is that the key in my view, okay, the key in my view to successful employment, and I mean this from a personal standpoint, not just a legal standpoint, is create value, okay? Be part of the solution to problems and not part of the problem. In other words, if you go and you produce value, demonstrated value to your employer, then it's going to be painful for them to let you go, okay? So, you want job security, prove that you're valuable, okay, is the best thing to do. But whatever you do, don't sit there and say, well, I'm going to sue my employer, for, you shouldn't have terminated me, and just sit around, waiting for my ship to come in. Because the ship may never come in this sort of thing, okay? Now, obviously, when you've got we've got conduct that violates rules regarding discrimination and so forth, that can be a different ballgame. But don't get the idea that you can just haul off and sue the employer anytime the employer doesn't do what you want them to do. The fact is that they hold a lot of power, and as an employee, you do as well. You just may not realize it. So, I hope I didn't rain on anyone's parade today. At any rate, signing out, and I'll see you next time.